My name is Rafael Gomez, and I'm the director of the Center for Industrial Relations and Human Resources. It's an honor to be here. This is 40 years of lectures and nearly 20 years of awards in the Sefton-Williams name. This award originally given to or honored in the name of Larry Sefton, and later Lynn Williams was added. This is an old building. There's noises that are coming from this radiator, which I don't know if are being amplified throughout the room, but not to worry. I'm sure it's all fine. Before we start, I wanted to acknowledge the land on which we stand and are using today. This land operates for thousands of years, as it has been the traditional land of the Huron-Wendat, the Seneca, the Mississaugas of the Credit. And today, this meeting place is still the home to many Indigenous people from across Turtle Island. And we are grateful to have the opportunity to work on this land. Today's itinerary, even though it says 4, those of you familiar with U of T know we start 10 after every hour. So we're on time, okay? Don't get too worried. We will present the award first, and after I introduce our award winner today, the brief bio, I will ask our award winner to come up to the podium. He will say a few words. The award will be presented, and then we will proceed to our talk this evening given by Professor Adelle Blackett. After, there will be a chance for the audience members to ask questions, and I was told, because this isn't on the screen, there's a reception after, which is right down the hallway in the gallery grill. So if you can stay, there'll be food, drinks for those of you in attendance, and you can mingle and chat with our illustrious award winner and our speaker as well. So those are the proceedings. That's the order for today's Sefton-Williams lecture and award ceremony. And I'd like to now talk a little bit about the award. The award has been given since 1997 in conjunction with the talk, which started in 1983. Past award winners include a who's who of the labor relations and labor law community. Former labor leaders like Bob White, former academics in labor relations like Noah Meltz, former political leaders and current political leaders like Ed Broadbent, Olivia Chow have been awarded this honor. Today, as you can see, the award winner is Owen Shime. Owen has a long history of involvement in the labor relations community in Canada. His rulings, either as an arbitrator, adjudicator, working for boards, tribunals, have influenced profoundly the labor law precedents that we use in Canada. I've had occasion now to talk with Owen several times since the award was announced. Each time I learn something new about our own labor relations history. Things like how postal disputes were actually settled in the past. Not in the way that you think, always strategically bargained over, but sometimes through the relationships that are built between individuals, hence the term labor relations. I won't go into the details of the pool hall game. You might want to tell that story, how the postal strike was settled in the early 1980s. Owen's rulings have had a profound effect on Canadian, not only labor law, but law in general. Supreme Court cases have used rulings that were made by Owen in the labor arbitration world or in the tribunal world. And these have had a profound effect on our labor history and our current labor relations system. Without further ado, I want to invite Owen up to the podium so he can say a few words on behalf of this award and also to speak about his career and to tell you a little bit about his story. Come on up, Owen. Here's the mic, and you're about as tall as I am.
Thank you. Well, I'd like to thank the university, the faculty, and the committee for this honor. I did not know all the people that were involved in the award, some of them who I now recognize, and I'm honored to be among them. I probably one of the few people around that knew Lynn Williams and Larry Sefton. Larry Sefton, not too well. I had met him through Alan Borovoy, who was also an award winner. Alan, many of you know him as a civil libertarian, but Alan began his career with the Labor Committee for Human Rights. And in that capacity, he met Larry Sefton. And when he introduced me to Larry, he told me that Larry had been a mentor and an inspiration to him throughout his career. So Larry Sefton was honored not only for his contribution to the labor movement, but he also contributed as a mentor to one of Canada's outstanding civil libertarians. I had the honor of being the arbitrator in a number of cases with Lynn Williams. And Lynn Williams, in my view, was one of the great steelworker representatives. The steelworkers, when I had my first arbitration with Johnny Fitzpatrick, who was the Metro Director of the Steelworkers. And the steelworkers always trained their representatives. In my view, initially when I started, they were probably the best union, and they had the best representation of any union in the labor movement. Others caught up to them. I think with the exception of Bob White, the steelworkers representative stood out. Lynn Williams was also remarkable. He was the consummate gentleman. He was an advocate for workers. He was a vigorous advocate for workers. He was always a gentleman. He always knew his case, and it did not surprise me that he ultimately came to lead the steelworkers in Canada and in the United States. He was one of among many steelworkers that I learned a great deal from. John Fitzpatrick, who I'll mention, was another. I always remember John Fitzpatrick when I asked him about a strike. He said to me, "Any damn fool can take them out. The trick is to know how to get them back in." And you should know that when you watch the current postal strike. At my age, and I started arbitrating, I had my first arbitration in January of 1969. And receiving this award makes me look back with some nostalgia on my past life. But what the most important thing to me in my past life has been the support and comfort that I've received from family and friends. That probably exceeds any of the accomplishments that you read here. My parents, who were immigrants, encouraged me to go to school, and my brother and I became the first in our family to go to university. I then had the support of my late wife, who was a classmate of mine at university. She unfortunately died very young. But she became an English and history teacher at Oakwood Collegiate. And when I first started writing arbitration decisions, she looked at my decisions and said, "There's too much legal stuff in here. You've got to write so that the people that appear before you understand what you're writing about." And I tried to do that, and hopefully I may have succeeded somewhat. As I said, my wife left me too soon, and sorrowfully, I became the sole parent of a pre-teenager and a pre-teenage son and 3 teenage daughters. I considered it both a responsibility and a privilege. It was a responsibility to bring them up, and a privilege because they have now, because I had to exercise whatever talents I had and being a sole parent and raising 4 children. They have all become contributing members of society, all professionally. They are a devoted family to each other and to me. They certainly helped me in times of COVID and continue to give me advice, probably twice as much advice as I ever gave them. they have all married and spouses who have also contributed. I had a friend who once said to me that you get old when your memories exceed your dreams. But I have now 5 grandchildren, 3 of whom are here, and 2 who are away at university. And I'm able, at my age, to look beyond the abyss to share in the dreams of my grandchildren, which I think keeps me somewhat younger and somewhat more vigorous. And finally, in these waning years, or what Shakespeare referred to as the last stage of all, I now share my life with my partner, Penny, whose humor and kindness contributes to growing old, and with whom I share are the slings and arrows of outrageous old age. I want to just talk a little bit about arbitration, because very few people have written about some of the earlier stages of arbitration. In the early years, in the 50s and 60s, most of the arbitrations were conducted by county court judges. And somewhere in the mid-60s, Jean Chrétien, who became prime minister and was minister of justice, said that stopped the county court judges from moonlighting and turned the case over to arbitrators. There were very few arbitrators at that time. Ted Weatherall, I think, was the first full-time arbitrator in Canada, to his credit. I think I may have become the third after Howard Brown. But what happened was that there was an influx of academics who had the time and who had the background to arbitrate. And so there was a cadre of professors at Queen's, at Western, and the U of T who fused the academia with the practical people who were deciding arbitration cases, many of us who had been at the Labor Relations Board. That really created a whole new body of arbitral jurisprudence. It's a term I don't like to use, but arbitral jurisprudence. And David Beatty, who was a law professor and an arbitrator, and who is best known as one of the authors of Brown and Beatty, which is a standard text now on labor law, said to me that in those years, the arbitration decisions, once the county court judges were out of it, had a trajectory that was equivalent to the trajectory of mercantile law into commercial law. As simultaneously, Mr. Justice Arthur Kelly of the Ontario Court of Appeal was asked to investigate the arbitration profession. I had a long conversation with Mr. Justice Kelly at that point. He had come from the Ontario Court of Appeal, and he said to me that he was surprised that the arbitration decisions in the late 60s and into the 70s were some of the finest legal writing in the country. It was equivalent to that of the Ontario Court of Appeal, which at that time was the best court in Canada. I am very proud to be associated with some of the people in the arbitration field at that time who moved the arbitration process along in the 70s and 80s at a clip that has rarely been seen. There were some of the great arbitrators at one point, you may not know it, but there were 3 or 4 deans of law schools who were arbitrators. Certainly some of them you would know. Harry Arthurs, who introduced me to arbitration and became the president of York University, and was an outstanding arbitrator. Most of you would know David Johnson, who was the dean at Western, because he used arbitration as a springboard to become Governor General. But he was a very fine arbitrator, and I mourn his loss. Arbitration has been a wonderful occupation for me. I think perhaps apart from the decisions, one of the best things that we did was when Harry Arthurs and I became heads of the education relations in Ontario, which was ultimately scuttled by Premier Harris. We began the appointment of women to the arbitration field. And that was an inflection point where we were able to give a great deal of opportunity to women to enter the arbitration field. When I first entered, there were no women. When I was on the Labor Relations Board in the early 70s, I once, in a discussion about whether we should have a French-speaking panel, suggested we should also have a women's panel. And I remember one of the members saying, well, we could not just have a woman chair at the Labor Relations Board. We needed a union representative who was a woman and a management representative who was a woman, because we could not sit in mixed panels. Since then, and since the entry of women into the field, there are days when I am on an arbitration board and the union nominee has been a woman, the management nominee has been a woman, and the two lawyers presenting have been women. And I'm happy to have had a hand in all of that as well. I am blessed in a way that I never anticipated growing up here in downtown Toronto. I used to go sledding where the Sigmund Samuel Library now is, and I never thought that one day I would be addressing a group at the university in this hall. So I would like to thank the faculty again, and the university, and all those who were in and the committee, and all those who were involved in honoring me today. I thank you, and thank you for being here.
By the way, our center is one of the few centers that has awards, which are very hard to get nowadays, which are signed by the president of the university or the principal of a college. So this is one of those awards. And I will hand it to you right here in front of the podium. Maybe Andreas, our communications person, will take a photo. Yeah, perfect. And any family members want photos? And first. Exactly. That was wonderful. And that was just a taste of some of the insights that I've gleaned in talking with Owen over the past month or so as we've propelled ourselves to this event today. Thank you for sharing that. I think we'll hear more from you in the near future. I hope to. Thank you. Thank you, Owen. So part one, on to part two. Another excellent summary is in your package of Adelle's background. I won't speak to every detail here because it's lengthy, and it's even more lengthy in your brochure. But just to tell you a little bit about the journey that brought Adelle here, I was reminded that this journey started in 2020, 4 years ago. Adelle was asked then if she would participate in our annual lecture series by my colleague, Professor Dion Polar, who was the director at the time. And we couldn't make it happen then. It was sort of the COVID years. And then Adelle was asked to become the person who was going to look into updating and addressing the changes to the Federal Employment Equity Act. And that was a long journey. I think how many pages later? Anyway, a report was written. I had the pleasure of helping Adelle in that process, contributing an academic addendum, if you will, to that report on how workers could get involved in updating the Employment Equity Act. And eventually in the actual legislation, there were features of Adelle's work and our work that we were commissioned by Adelle to help her in that journey. So I'm very honored to play a small role in that piece as well. Adelle has a long career built on both the credibility and the astounding output as an academic, but part of this speaker series has always given attention to not just the academic who buries their head and publishes maybe great, important articles, but who also has a hand in shaping the world around them for the better. And Adelle is clearly one of those candidates. So without further ado, I'd like to invite Professor Blackett to come up to the podium and address you all on today's talk, which now I will hand over to her.
I've got a mic. Got a mic.
Oh, we've got a mic. She doesn't need this. She does need this. So propel your, or you can use that.
I'll use this. Yeah, that's perfect. Thank you. So thank you for that lovely introduction. I'm deeply honored to be delivering this lecture commemorating Larry Sefton's and Lynn Williams' historic leadership in the United Steelworkers and frankly, the transnational labor movement that they epitomized. So they're a reminder for me that our labor movement has been transnational and concerned with equality at work for a long time. So the initial invitation, as Raphael has kindly said, to deliver this lecture came during the pandemic from the person who would also go on to be my cherished vice chair on the Employment Equity Act Review Task Force, which ran from July 2021, so Professor Dion Polar. And the task force became the reason why I had to defer the invitation. So I'm immensely grateful to you, Professor Gomez, and for the generosity and the graciousness, as well as to your formidable team, Andreas and Joanna, and members of the Sefton-Williams Memorial Lecture Committee. And thanks also to the legendary Emeritus Professor Morley Gunderson, who I am delighted finally to have met in person, and Professor Ting Ting Zhang and Courtney Coble for the warm welcome today. So you should know that the Employment Equity Act Review Task Force held well over 100 consultations, spanned 51 days of meetings, received an additional 400 written submissions. We commissioned enhanced engagement reports by representative organizations of First Nations, Métis, Inuit workers, workers with disabilities, the two groups that we were asked to consider for inclusion within the Employment Equity Act framework, 2S LGBTQI+ workers and Black workers. And the report canvasses a voluminous body of past studies on employment equity and incorporates extensive statistical, comparative, and international research. But more than this, the report focuses on the voices of those who we heard, and I hope conveys how much the vision of an equitably inclusive workplace means to ordinary working people and indeed to all of us. What we heard was that there was a wide consensus across employers and workers, governments and civil society, academia and trades, that employment equity is essential to a cohesive and pluralist Canada. So I was particularly taken by the people who came before us, shared their, frankly, dispiriting experiences of harassment and discrimination at work, and explained that they showed up to our consultations because they did not want another generation of workers to experience the same thing. And I was deeply encouraged, including by the trade unionists who told us that they looked around their own workplace, considered their own work lives, recognized how unrepresentative they were, and explained what they were doing to make things change, and added that they were committed to be the voice of change. So the report was publicly released in time for International Human Rights Day. And I'm just going to get this one in. Last year, 2023. And it was launched along with historic governmental commitments and was received, frankly, for many in this dark world moment that we're living in as somewhat of a bomb, an encouragement to believe that we can still make a difference through our public policy on equity at work. So a year later, many of us are increasingly heartbroken. Parts of our world are slipping, as you know, into authoritarianism. The term EDI or DEI is thrown around, frankly, like an epithet. At some level, this evening's talk is as much about where we are today and where we go from here as it is about the report itself. While the report submitted to the Minister of Labour in April 2023 could not anticipate the world we would be living in today, it could apprehend it from some of the signs, and it sought in a very humble way to shift some of the narrative. For we have a logic of us and them, and we have let that overshadow something incredibly basic. And that is that people across many demographics know that they are being deprived of a better life, feel how much risk is being transferred onto their shoulders, and recognize that a cry of rage might be the only language that's heard when the relationship between, on the one hand, equitable inclusion and democracy at work, and on the other hand, political democracy has been so deeply severed. In other words, we allow the divisions that sustain structural inequality to deepen when we fail to acknowledge and address them, not as separate from labor law, but as part of what labor law is for. So my presentation tonight is a call for our labor community and for our democracy to take the transformative values that underlie employment equity so seriously that we categorically refuse an us for them logic that has instilled paralysis rather than necessary movement in this profound moment of discontent. I argue, in other words, for a renewed commitment to employment equity as labor law. And now I must ask where the clicker is. Thank you. All right. So the presentation will take place in 3 parts. Part 1, employment equity, what happened? Part 2, on transformation, a 3-pillar framework, and Part 3, employment equity as labor law. So the report begins with the following reminder. Employment equity is a proactive approach to achieve and sustain substantive equality in the workplace. It is urgent and it takes all of us. The proactive approach emerges directly and immediately from then Judge, now retired Supreme Court of Canada Justice Rosie Abella's landmark 1984 Royal Commission on Equality in Employment. Rosie Abella coined the term employment equity and in the process took critical distance from 2 aspects of an increasingly counterproductive US narrative. The first, the language of affirmative action itself, and the associated logic that we were engaged in a process of reverse discrimination. And second, moving away from a rigid notion of quotas, a red herring, if the understanding is one of substantive equality rather than equality as sameness. After her own process of listening deeply to those who came before her, Abella called for 4 equity groups to be identified using the terminology of the time: women, Aboriginal peoples, with minorities, and persons with disabilities. The ensuing Employment Equity Act framework has been a symbolic cornerstone to how we have addressed equity. That is substantive rather than formal equality in the world of work. I say symbolic only in part because the federal legislation covers only slightly less than 8% of the entire Canadian workforce. For labor and human rights initiatives in federal law and policy tend to have an outsized influence, as you know, well beyond the actual coverage of the federal legislative framework across the country and indeed internationally. So the substantive equality framework at the root of Canadian constitutional law is also at the root, I argue, of the work of equity in our protections and part of what employment equity is about, that is transforming relationships. But what I observed in the first comprehensive review of the legislation that we conducted since it came into place in 1986 and then was modified in 1995 was instead a system that had been reduced to fastidious, indeed soulless, numbers crunching exercises devoid of real world nexus to the depth of the inequality experienced by real working people in real workplaces. And in the words of my colleague and former Sefton-Williams lecturer, Professor Leah Vosco, here in the audience, in her assessment of employment standards frameworks in Ontario, it was left to, quote, incentivize noncompliance. I also realized that something even more pernicious was happening. EDI itself was getting in the way of a deepened understanding of substantive equality. We were literally losing sight of something remarkably important, if particularly basic, that the reasons for the proliferation of voluntary EDI actions bequeathed to us by the United States that had started its own movement to destabilize the foundations of affirmative action, even before Justice Abella's report had been rendered with the Blackett decision and eventually an ongoing narrowed exception only of a diversity-based justification. And then ultimately, you know, the kiss of death, the 2023 SFFA decision by the US Supreme Court as it pertains to race in college admissions. These were not, resolutely not the same in the Canadian context, right? The US law on reverse discrimination, I found myself saying throughout the task force process, is not Canadian law, right? Canadian law requires us to reverse discrimination. This was one of the, quote, influential ideas that's not our own, but became such a deep part of how our own process of employment equity began to be understood. And then the focus on EDI initiatives of training for unconscious bias and the like became the replacement for actual employment equity measures and helped to instill a sense of helplessness in actually achieving employment equity. So performative or non-performative, depending on how you like to use those terms, but basically not meant to achieve or sustain employment equity results, achieve or sustain substantive equality. And so it became important to reframe. While diversity in the Canadian context is a fact, and inclusion might be thought of as a choice, in the Canadian context, equity is the law. It's the law not only because we have employment equity legislation, it's the law because of our substantive equality framework and because of the international human rights framework on equality that undergirds our understanding of substantive equality. History matters in ways that we have sometimes long forgotten. And in this report, it became important to make the hard claim about taking the specificity of the histories that undergird the need for employment equity very seriously. In stating this and in turning a lot of attention, frankly, in the report to the histories of the groups concerned, I recognize that a contemporary and deeply legitimate approach is to look to the data that, of course, establish adverse impact. And in no way am I suggesting that the historical demonstration is necessary to the legal test, but I am wanting to underscore that the turn to history is a turn to taking seriously how we understand our societies and our world of work, how we grapple with the weight of our past and understand the effects in a manner that, rather than stereotyping, historicizes and, dare I say, humanizes. Part of that history, then, that's too easily forgotten is that our first employment equity program in Canada, and Arbitrator Shime, congratulations, hinted a little bit at this, that the program in Canada was to ensure equitable representation of francophones in the federal public service. Far from being shrouded in a deficit mentality, it stands for a mature understanding of what it means to understand group rights and work to redress the ways in which groups may be excluded and to make our workplaces and our polity more viable. So starting there reframes how we understand equitable inclusion and moves us away from a deficit model. When our task force was meeting, we were literally finding the mass graves of children who attended so-called residential schools and never returned. The fact that our societies were beginning a long and overdue process set in motion in large measure by the late Marie Sinclair to engage with the level of the dispossession and intergenerational trauma, set in other words, to center truth to any meaningful process of reconciliation. We learned too of the strictures of the historically privileged medical model, even in the current Employment Equity Act, which looks at disability as impairment and does not link disability to societal barriers. It also constructs disability in a rigid binary rather than in a more nuanced contextual manner, and rather than, in other words, in a societal model. We were similarly told of the devastating impact of the purge in the federal public service. The government of Canada has acknowledged that through the Cold War era, from the 1950s through to the early 1990s in Canada, the federal government employees faced a systematic campaign, literally, to purge them from the federal public service. We were reminded also to take a long view, including on actual labor market segregation, the kind of segregation that's largely been ignored or erased from public consciousness. And here I want to refer to the work of Professor Cecil Foster, who explains in his detailed archival analysis called They Call Me George, Black men from Nova Scotia were specifically recruited as porters, replicating a model from the United States South, alongside Black men from Southern US and British colonies in the Caribbean, and were subjected not only to de facto occupational segregation that led to grueling hours and poor pay as they served as the good housekeepers on the train, the segregation was also formalized by law, by labor law, including a 1926 memorandum agreement from the report of the Board of Conciliation and Investigation that ensured that segregation would be enshrined and legally sanctioned. It was part of the 1944-1945 agreement between CN and the Canadian Brotherhood of Railway Employees and other transport workers, and continued well into the 1960s. It continued through some of the cases, included cases after the Fair Employment Practices Act was introduced in 1953, and of course, after the introduction of the Wagner Act-inspired framework in Canada in 1944. So we should be recalling also the speed with which we moved from a place in Canadian law from specifically discriminatory provisions to an immediate innocence, a proclaimed absence of any discrimination at all. This becomes important because it reminds us of the work that needed to be done and that it took a long time to start to do between facial neutrality and actually proactively working to build equitably inclusive societies. So when the Employment Equity Report was launched in 2023, this historic announcement was made. 2 new designated groups would be created, Black people and 2 LGBTQI+ people. The term Aboriginal peoples would be replaced with Indigenous peoples and using an approach that is then distinctions-based. The language of visible minorities, almost universally despised, was changed to racialized peoples, or would be changed. And the definition of persons with disabilities would be aligned with the Accessible Canada Act, adopting that social model that I referenced earlier to make it more inclusive. These were framed by the government as first steps, the proverbial low-hanging fruit of change that would ensure that the report would be put in place. And I'd like here to take the time to take you through some of that broader framework. For the report itself stood for the proposition that there's so much more that's required than adding a few groups or changing some definitions. In other words, that employment equity is not, won't happen by a stroke of a legislative pen. There must be a commitment to a sustained framework for change. So, and here we'll move to part 2. The framework is one of renewed approach, one that builds proposively, pragmatically on other regulatory frameworks and innovations, including in pay equity and accessibility, to enable us to both achieve and sustain employment equity. And it does so by building resolutely on our substantive equality jurisprudence and holding it accountable to a shift, the shift necessary to move away from a focus, sometimes implicit, sometimes all too explicit, that is resolute in its acceptance that substantive equality is meant to be achieved and sustained. And so the framework has 3 pillars: implementation through barrier removal, meaningful consultation, and regulatory oversight. The first, the barrier removal pillar, centers on the need to move beyond the model that I referenced at the outset, basically a deficit mentality around equity, and focuses therefore on building what you might say is the case law on substantive equality very much into the way that we're thinking about our framework. And so you might say it seeks to reclaim the power and the high watermark in human rights decisions like the Mayor decision from the Supreme Court of Canada, and even embrace a framework like that in the Dion case that Justice Adelle Health, I think it is, yeah. Are you still hearing me? Yes. Okay, great. On occupational safety and health, as per the Dion case, in which it is the workplace and not the pregnant woman that needs to be rethought. in the context of hiring and accommodations. So decisions that emphasize the need to train the mind to look a little less at the individual complainant and how they can be provided with an individual accommodation, and rather more resolutely on the workplace and how structural barriers can be removed to make many of those individual accommodations seem less. Chapter 4 of the report is replete with examples across the employment lifecycle of how those barriers might be identified and removed, and indeed how merit itself can be rethought, drawing interestingly on many of the reports prepared often by Supreme Court of Canada justices, former justices, about how you rethink the cultures in places like the RCMP or the Canadian Armed Forces. One of the key ways to think about barrier removal is also to think of what we haven't actually achieved. And this statistical slide gives an all too compelling example of the over 20% of occupational categories, almost 20% of occupational categories, 98 jobs that remain over 90% male. Some of the examples are identified here, and while some offer gendered explanations, just think about some of that, like the overrepresentation of in airline pilots of very similar working conditions and are more representative. So not surprisingly, the Employment Equity Report recommended something that one actually still needs to say, but that although some improvement is seen in the employment equity, very important to retain that group and indeed to go deeper, disaggregate, and engage on an intersectional level. Okay. In fact, the approach adopted is one of data justice, and it is a backbone of substantive equality. The chapter emphasizes that data collection is not an end in itself. It draws actively on approaches that have emerged from the British Columbia human rights experience and is rooted in Indigenous traditions, the grandmother principle. Data collection, if it is not understood to be done in alignment with the human rights purpose, can cause harm. Right. So a consultative approach, an approach rooted in the why of human rights, and that propositive approach should affect a number of features, including, as was discussed in this chapter, how we address issues of privacy, not as a shield or indeed not as a sword against employment equity, but indeed deeply complementary in purpose. On the specific examples, I'll just share one. There's many in the 500-page reports, but really this is almost deeply intuitive. When employment equities calculation of labor market availability takes workers who are overqualified, take the example of the taxi driver with a PhD, and counts them in the labor market as taxi drivers rather than in their field of specialization to assess their labor market availability, we have a problem. We need to be turning our attention to challenging rather than replicating the barriers to equitable inclusion in the manner in which the data are engaged with, hence a data justice approach. Okay, so the second pillar is meaningful consultations, and from a labor relations perspective, it can hardly be more crucial. The theorizing in this section, as Professor Gomez mentioned, was supported by a very helpful background paper that is indeed heavily cited in the chapter. The report refuses a logic that says that equity is imposed from above and done for groups, and rather emphasizes that it must be with them. There's a jurisprudential logic that flows through this, but ultimately the claim is one that can best be summed up as the South African disability movement has summed it up, and as has been transnationalized, and it's literally nothing about us without us. It calls for a joint employment equity committee in the practical manifestation of that in the employment equity framework. But I want to emphasize that this becomes into occupational safety and health and pay equity becomes a way to draw lessons of labor law in. Okay. The third pillar is regulatory oversight, and the upshot is that we concluded that it was quite simply broken in the federal context. Frankly, I was flabbergasted to learn that the framework has become subject to erroneous legislative interpretations that have literally stripped the framework that we currently have of meaningful executory content. Consider that the English version of Section 11 of the Employment Equity Act was being read to focus exclusively on requiring employers to build a plan that, if implemented, would constitute reasonable progress towards implementing employment equity, but they weren't actually being required to make reasonable progress towards achieving employment equity. However, a close read of the French version of the law, which is equally authoritative, confirms that the words "if implemented" aren't there, and that instead the employer is required to ensure that the reasonable process is being made. So the French version of the law was not guiding the interpretation. The regulatory oversight was not being undertaken, and the legislation was being reduced to merely non-performative acts. Okay, so the chapter offers a detailed discussion of the challenges surrounding also what has become a bifurcated system for enforcing employment equity between the labor program, which implements the legislation and is in contact with employers, versus the Human Rights Commission, which has auditing responsibilities. And I should specify the very, very small team of 11 people at the time that is responsible for the entire federal jurisdiction's compliance with the legislation. But beyond the limited resources, the audits were never shared with labor program staff. Legislative restrictions were cited. I could go on. There were a litany of concerns, but it became apparent that an alternative was necessary to begin to support an approach that saw proactive regulatory compliance as essential to this framework, and an employment equity commissioner housed in an office of equity commissioners with the pay equity commissioner and the accessibility commissioner, and commensurate financial support was the core of the recommendation. Okay, so that's the framework, and it's been overall quite well received, widely discussed, but we wait. So there have been public commitments made. The report remains with the labor program. A discussion paper has now been prepared. Further been undertaken on implementation throughout the summer. Now 173 submissions have been received with a view to discussing what changes will go forward. For its part, the Canadian Labour Congress, in a public statement released in March, acknowledged the extent of the consultations already undertaken by the task force and asked for the recommendations to be implemented. So much could be said, of course, about the current broad climate of backlash that may have a foreboding impact on the work of equity. And one could be forgiven for wondering whether the time is right, whether employment equity changes might be the kind of thing you don't want to engage in a moment of deep challenge. We know at least one government has been toppled for less. But I'd like to acknowledge the weight of this moment but also quite resolutely try to move us past this point, and to do so by returning to a proposition that I suggest we need to take very seriously, that employment equity is labor law. In other words, we will not be able to challenge the growing labor market inequality and unequal bargaining power that are the source of much of the discontent unless we grapple with the very divisions that our economic system sustains precisely by attaching unequal outcomes to the identity-based differences that are at the heart of employment equity's response. This is something we seemed to see quite palpably at the heart of the pandemic, when we could see daily the differential impacts on those who worked and those who could stay at home and shelter. In still other words, what would it look like if our labor relations movement took it upon ourselves to challenge rather than accept the negative politicking, even look beyond the so-called business case for equity, and underscore that employment equity is a regulatory response devoted to addressing a particular but integral set of questions that are central to building an inclusive labor market that stops leaving working people behind. That employment equity is about and takes all of us. The focus on the why, equitable inclusion, leads us to cover some of the thorniest questions in labor and employment law. They all relate to the Employment Act framework, but they do so distinctly, and they do so in three different ways. First, the Employment Equity Act framework cannot stand alone. It needs to be understood as an important part of a broader comprehensive law of work. Much of Canadian labor and employment law, including the collective bargaining system and later minimum standards protections and safety and health at work protections, seek to reduce the disparity between the rights of the individual as a worker and the rights as citizens. Employment equity requires strong surrounding labor and employment laws upholding decent work in the changing workplace. It contributes by building in a transformative framework that includes the meaningful consultations, and it attempts to reduce the prevalence of precarious work, and that complements attempts to achieve substantive equality at work. In this regard, the coverage is not quite as broad coverage the way other labor and employment and human rights law imagines coverage, but it is significant. In other words, and the second, the purpose of the Employment Equity Act is to secure social justice through equitable representation of workers, but not just in any jobs. It's unabashedly about making sure that all workers have an equal opportunity to be represented in good, stable jobs, what internationally, including the UN Sustainable Development Goal number 8, tends to be referred to as decent work and economic growth. And that UN Sustainable Development Goal entails promoting sustained, inclusive, and sustainable economic growth, So decent work for all was an including in part 3 of a moral imperative to ensure that decent working conditions for the most vulnerable workers in the workplace are in place. Some will look at the employment equity framework in light of this and wonder whether those workers who are currently covered, that is, employees in large standard employment relationships, are the workers who are most in need of assistance compared to other more vulnerable workers. And our task force considered these views and found that a somewhat different conclusion was important. Employment equity was never meant to be a complete response, but it can be part of the response and it can correct a distinct set of problems. Historically excluded groups have stood to benefit from employment equity alongside and relation to the other workplace measures that foster substantive equality, namely pay equity, accessibility, human rights protection. Employment equity creates opportunities for the inclusion, especially for those who've been excluded and relegated to precarious jobs. There's a focus on achieving and sustaining employment equity through the removal of barriers, and as a matter of social justice into good, stable jobs along with others. And the transformative framework insists that this be done in a consultative manner, and the framework for regulatory oversight retains a space for governmental responsibility. So it follows that third, we still need to know what's happening around jobs when the conditions are more precarious and who is occupying precarious jobs if we're going to be able to foster employment equity. And we know also the disproportionate representation of equity groups in precarious jobs with disproportionately low incomes. And so this is part of what employment equity seeks to correct as one piece of a broader puzzle. And so it's part of the holistic response in labor and employment law that tells us or gives us insight into employment equities, why. And in some quite concrete ways, then the report then takes us through a number of ways in which employment equity can provide even greater information in the workplace, and recommends that part of the reporting requirement should cover not only employees in any given workplace, but also dependent contractors who may be within the fold, in keeping with what's happening in the pay equity legislation, with a view to providing that complementary or broader understanding of the workforce. So in this moment of populist politicking, that has been referred to by Judith Butler as a moment of emancipated rage, how might we reaffirm in pragmatic ways what labor law is for in societies that are as diverse and as pluralist as ours? Going back, of course, to some mythical great past is not an option. Engaging with the specificity of our histories and summoning the courage to build into the future, how we would like to see our society evolved is not. And so the Employment Equity Report tries to focus not on what might be done in the abstract, but rather what can be done concretely in context to transform employment equity to achieve and sustain substantive equality in Canadian workplaces. And in light of this, I conclude ultimately with a bit of a plea for what may at first seem counterintuitive, but I would suggest is something that labor has always done. It's refused any suggestion, for example, that the freedom of association is simply aspirational, handed over by the state to be turned on and off depending on the political winds. Substantive equality should be no different. And social movements in and around the world of work are not going away. Employment equity is to be achieved and sustained, and to reclaim labor laws. Why? By building a deepened understanding of substantive equality into the very fabric of solidarity, precisely in a worldwide moment of rising hate, intolerance, and exclusion, is a critical choice to affirm our ability, literally, to work together to foster equitable inclusion for all. Thank you.
Nice. Mike. Just has to go on for a second. All right, great. I feel like Mick Jagger here with the, all right, let's bring it down. Thank you so much. So insightful and so powerful. We usually have this moment now open to our audience to ask questions. And by the way, for those of you who enjoyed this talk, you'll be able to get a presentation that you can access after, alongside all of the other presentations which our library has archived for you. So lots to digest here. That was deep. So thank you. We have two of our students who are going to be offering up microphones for anyone who would like to ask a question of our speaker. Don't be shy. We're amongst friends. Oh, question right here, right in the middle. Nilu, I caught this hand first. If you just introduce yourself.
Sure. Hi, I'm Bethel. Hi, Adele. Thank you so much for the talk. I'm a PhD student and I'm looking to study the Employment Equity Act in the context of post-George Floyd murder protests. I wanted to ask you, have you noticed this sort of EDI backlash in organizations, US and Canada? And I guess how have your reflections sort of given this thought? It feels like it's happening in current times, and the report sort of, is published at a time that's needed, but then you see the backlash quickly happening. So I guess how do we reconcile all of that?
Yeah, it's the question. I think the backlash is all around us, and it's observable in some of the largest employers who were just talking about the Amazon example. Part of the challenge is assessing how much was actually being done before through the language of EDI. It was ubiquitous, but how much of a shift has it actually represented in terms of people in jobs that reflect the full diversity of experiences and expertise, right? But yes, we're in a moment where moving away is clearly observable. In the US context, even though the SFFA decision on affirmative action is limited in its scope, in the educational context, it's been received as a directional move, right? And has had an impact. In the Canadian context, we have a really long border, and ideas travel even before our frameworks shift. And we're certainly witnessing many of the positions being closed or not replaced, shifted, converged, including in the educational sector. And so it's a source of concern. And so you can appreciate with this report, there's been a delicate navigation. On the one hand, offering the critique, right? And thinking closely about all the ways in which the focus on EDI has moved us away from anchoring well-intentioned initiatives into a clearer attention to what substantive equality means and requires through our constitutional framework and through our human rights legislation at the provincial levels, right? And that's kind of the focus here, not to attack an already vulnerable space, but to make sure that we're understanding why it is that an approach to equitable inclusion is part and parcel of how we understand our legal frameworks, including our labor law frameworks. Yeah. Thank you.
Other questions that we can ask right there. There's one.
Hello, my name is Justin Chen. I'm a PhD student in workplace learning and social change. I just was curious on data justice. Specifically, you talked about data collection must be done correctly, and you mentioned the grandmother principle. Could you elaborate a little bit more on that?
Yeah, sure, sure. And I would also point you to the reports of the BC Human Rights Commissioner that preceded what in the British Columbia context became a legislative framework around the collection of race-based data guided in this principle. And the framework was basically that data collection can be dangerous, right? If the focus, the reason for the collection isn't clear, isn't reflected in the manner in which the data are collected. And so the data justice model roots itself in an approach that is fundamentally consultative and that is clear about aligning that collection with the reasons for the collection and carrying that through. And so building committees that are representative, making sure that there's engagement, making sure that there's a careful framing as well of how data come out. And I think you're seeing that more and more, frankly, with the work of StatsCan when it reports on data that concern particular communities, that focus groups are put in place with members of the communities who analyze and discuss the narrative that accompanies the number and frankly how the numbers themselves are come upon so that you have a portrait that is understood to be more accurate, right? And also more intentional in its concern for refusing to repeat ways of collection that are harmful. And so you've got increasingly careful attention to the frameworks that are put in place. You also see more attention to communities themselves collecting some of the data. And this is particularly the case in respect, of course, of First Nations, Métis, and Inuit. So data sovereignty issues are embedded in how one thinks about data justice. So there are many aspects, and the reports chapter takes us through how a data justice framework can then support how we think about questions like self-identification for the purposes of employment equity, which for the moment is a voluntary principle, and how one can incentivize supporting the collection of that information. It was distressing to hear from members of employment equity groups who preferred, when they could, to hide their identity, because rather than assuming that they were actually going to be supported, they anticipated discriminatory responses, right? So that was a piece. And there were a range of other elements that flowed through the data justice as well, including how one disaggregates data to get a better portrait of which groups were facing disadvantage. So disaggregation of Métis, First Nations, and Inuit communities in respect of disability and in respect of gender. Right, you're then getting to smaller and smaller groups. You're getting to different and intersecting forms of disadvantage. How can that kind of information be collected in an employment context in a manner that is attentive to concerns around privacy, but also concerns around, ensuring that one is not fostering deepened stereotyping, but actually getting supports to the groups that are concerned. So there's a lot there. And the framework helped to think past some of the impediments to doing the data collection by focusing not so much on whether, but how.
Question, and I remember when data is captured carelessly and ill thought through, the CBC case where people's private information became public, and the approach that is in the report is one that is thoughtful, it's measured, and it's detailed. It's like when theory meets practice, it builds a better model. Great question. Also my TA, by the way, so I was very proud. Thanks for asking. Any other queries and questions? Right there in the middle again. If you just introduce yourself too before the question.
Yes, good afternoon. My name is Wayne. Professor Blackett, has employment equity been more successfully implemented in the public sector as opposed to the private sector? And if so, why?
Yeah, another good question. Thank you. I would love to be able to say that it is better implemented in one or the other. What I became really disturbing was the lack of monitoring, right? And then the paucity of auditing to be able even to get to that, to an answer to that question. So we met with representatives from across government, met with many sectors covered by the federal legislation as well. And we saw tremendous variation within both, right? And real differences in results in both. And what became apparent was that workplaces that were really intentional about meeting employment equity targets were able to do a great deal, right? But that they weren't getting that support from the regulatory oversight already in place to support the legislation. The audits were hit and miss and very few. It was frankly easy for various workplaces simply to wait to be audited and then start the process. Right? And so you have around the federal public service a range of employee-based networks, a joint employment equity committee structure already in place. These help to start to foster at least dialogue around underrepresentation, but I can tell you there was a lot of anger and concern expressed by representatives of many of the employee structures, because it was almost as if the review process galvanized discussion about what wasn't happening rather than reflected on what wasn't happening and what had been happening over the past 40 years. So there's no right line between the two, unfortunately, and a lot of concern about what needs to be done to support change in both the public service and in the private sector. Yeah.
Next question. Any other questions? I had a question, which I still will, if there's still one that wants to go, but I wanted to ask it now as we prepare to engage in more less formal talk. You mentioned at the end, in one of your last points, that the Employment Equity Act can only do so much, that it's a federal jurisdiction first of all, and 8% of our workforce is covered. And the real work maybe has to happen by society and its actors. What role would labor law, labor relations, shall we put it, the fact that many workers are negotiating collective agreements all the time, can the good work of your report get embedded there and therefore have a much faster, quicker, impactful effect?
Absolutely. Yep, thank you. Exactly. The right question and point. And one of the things we reviewed was several of the reports of workplaces where employment equity is being embedded into the collective bargaining structure. And clauses are put in place, but more than the clauses, you've got committee structures that enable information to be shared about employment equity and conditions to be negotiated that enable employment equity conditions to be moved forward. Part of what the report's proposals anticipate, especially through the meaningful consultation and the Joint Employment Equity Committee structure, is that that will foster greater opportunities for not only the information to be shared, not only the discussions about employment equity, but for that to be embedded in the work rules and the collective agreement and the committee structure and the structure of reporting that it anticipates allows workers or others in the workplace context to trigger an auditing process that can help to keep a continuous movement going towards employment equity action. So yes, it's part of the deeply organic relationship. It's part of refusing an approach to employment equity that sees it merely as an employer responsibility to report and a government responsibility to respond to the reports, and carves out the space for workplaces to keep employment equity alive in the clauses and in the day-to-day interactions between the parties. So it's absolutely the response. Yep. Thank you.
Wonderful. Nilu? Oh, wonderful. Who's going to read it? Nilu, can you read it? So Nilu will read you the online question. It's a hybrid event.
If data collection shows underrepresentation of a group, particularly persistent underrepresentation, what steps are recommended in the report to improve representation? And in practice, are the steps being taken to improve representation in the public and private sectors?
So thank you for reading that out. If I understand correctly, the question is what measures are put in place to address underrepresentation? Yes, have I missed a part of that?
That was it.
Okay.
If there is actual evidence through an audit that employers falling short.
Yeah, so, okay. So thank you for that question, because what it allows me to stress is that the auditing is meant to include, one, the numbers, right? And there's been a lot of tension on calculating exactly the labor market availability on the one hand, and exactly what is the number, the target number in a workplace, and to make those match. But what you get with that kind of process, and what you have gotten over the past 40 years, is a bit of a revolving door approach, right? So the numbers don't actually map onto the workplace or the people or the context. And workplaces may remain underrepresentative, even though they are attracting people, they're not retaining people because the conditions haven't changed, and you get basically an approach that hasn't actually removed the barriers, right? And the employment equity framework includes more than just the numbers. It is literally about understanding the workplace, doing a scan, thinking about what practices or what conditions within that workplace are leading to underrepresentation and making workplace changes. So that means that if you've got a data collection and you identify that there's underrepresentation, don't just stop at the numbers, right? There's a recruitment process, but there's a broader workplace compliance dimension that needs to be taken into account. And that is an ongoing responsibility. And so part of what the report does by emphasizing the barrier removal is to put the attention on structural change internal to the workplace context. And so that can lead to a broad range of changes like addressing harassment policies, right? Making sure that there are a range of measures in place to make workplaces safe and welcoming, make workplaces such that workers won't just come and leave in a revolving door process, but literally stay. There are many other examples of that, and they're canvassed in the chapter 4 of the report that takes a life cycles approach to thinking about how you address employment equity through barrier removal. And then the responsibility is, of course, to hire across the workplace the different jobs in the workplace that might be underrepresented, but to do the kind of structural work that ensures that the workplaces can be representative over time. So it's a much more organic process, and that means the audits need to do a lot more than simply verify the numbers, right? They're audits of the entire workplace environment. So a much more serious kind of 360-degree approach. And one of the reasons for moving towards that commissioner model is that it puts in place a structure that can be more supportive to the whole process of building employment systems that redress discrimination and move us beyond a fixation on this number of representation without paying attention to the factors that keep us 40 years later struggling to achieve employment equity.
Thank you so much. It's just a practical example. I think I read it in the report, but there's an example of an employer couldn't retain working parents in their workplace, mainly women.
Yeah.
And then the structure of the workplace was there were morning meetings at 8:30 and afternoon meetings at 3:30. That's when you pick up, when you give kids to the school and system and when you pick them up. So that's an example of you can keep a rotating job hiring and losing model because you will not retain anyone with a child in some caregiving or school. So recognizing that would be the true barrier removal and would then help.
Absolutely.